Hello, everyone. My name is Denas. Thank you all so much for joining us today in our webinar. A big thanks goes and shout out goes to Alex as well for always being ready to share his expertise with our community. I'm really hopeful that everyone tuning in today will pick up some new insights. I know I'm excited to learn alongside you. So our agenda today kicks off with Alex giving us a quick rundown on the latest developments in the US web scraping legal cases. And I'm particularly keen to dive into this as there have been some intriguing happenings in the courts that you might have caught wind of. After we dive into the latest cases, Alex and I will walk you through some real life scraping scenarios. We'll break them down from a legal angle. As we get it, not everyone has easy access to a legal team or can chat with the legal counsel whenever they need. So we thought it would be super helpful to share the kind of questions you might want to think about to fully understand what's at stake legally with your scraping projects. Yeah, and Mike to Alex.
Well, thanks so much, Denas, for inviting me to present with you all and with this community today. I always really look forward to the OxyCon conferences, which are usually in the fall, and so it's nice to be visiting with this community in the spring and talking again about legal issues that face the scraping community. And as Denas mentioned, there have been some really interesting court cases recently, some interesting developments that sort of prompted, he and I talk frequently about what's going on in the legal world of scraping. And so these recent updates prompted us to think maybe it's a good time to meet with this community again and talk about what's going on in the courts, and also to talk about some questions that frequently arise for legal questions that frequently arise for scraping companies. So I'll just briefly touch on a few cases that are either recently resolved, or are still pending in US courts that could shape how the laws apply to scraping and what scraping companies do. And then Denas and I think we're going to talk a little bit about some use cases, some questions that come up frequently in this world. So really briefly, just some key cases. One that I think many people in the audience were following was the Meta Platforms versus Bright Data case. So just to very quickly summarize it, Meta sued Bright Data, which is a company that provides scraping infrastructure and also scrapes data and sells data sets itself. So Meta sued Bright Data about a year ago, alleging that what Bright Data did violated Meta's terms of service, and then it also had a claim for intentional interference with contract. And so what was really interesting about this case is that both sides thought that they had such a strong case that they persuaded the court to do an early summary judgment. Normally, summary judgment motions are something that happen very late in the case, but here they wanted to do it right away, very early, and see if they could get rid of at least part of the case early on. And I think it was sort of an earthquake in the scraping community in January of this year, when the court granted Bright Data's motion and denied Meta's motion. And in particular, it was very interesting because the court it's a long order, and the court did a very thorough analysis of Meta's terms of service, analyzing what does it mean to be using a social media platform, in this case, Facebook or Instagram. Does it mean that you have an account, and once you have an account, you're sort of always using it and you're always bound by the terms of service? Or are you only bound by the terms of service when you're logged in and actually using the platform? And the court agreed with Bright Data and found that for a number of reasons, you're only using the platform when you're logged in. And so the prohibition on scraping Meta's data only applies when you're logged into the platform. And so the way that the issue was presented to the court was that Bright Data collected only publicly available data. It was not logging in to collect any data behind the password wall. So that was the only issue in front of the court. Does that activity violate the terms of service? And the court said, no, it does not. Now, Another development that was extremely interesting and took a lot of people, myself included, by surprise. The court left open one claim, that was Meta's claim for intentional interference. And I think a lot of commentators in the industry assumed that what was going to happen was the parties would resolve that claim because it was a not very important claim. And then Meta would quickly appeal the ruling. Instead, what happened was they resolved that claim and Meta decided not to appeal. And so the case is done. It's completely resolved. And there's been some speculation as to why. Some commentators think that the reason Meta decided not to appeal is this ruling was from a district court in the United States. That's the lowest level court. And so maybe Meta didn't want to appeal because they thought it's better to have one bad ruling from one lower court than to have it appealed and then confirmed by what would be the Ninth Circuit, a very large court here in the United States. And so that could be the reason, but nobody knows for sure why Meta decided not to appeal that ruling. But that was a very interesting case that many people were following, and the repercussions of it will also be interesting to follow. I think it's possible that Meta is going to revise their terms of service to get around this ruling. It's possible that other social media platforms who are watching the case will work on revising their terms of service to make it more clear that what the terms mean is no scraping anytime, whether you're logged in or not. And whether those amendments, if they change their terms of service that way, whether those amendments would be effective is a separate legal question that maybe a court will have to decide in the coming years. So that's sort of the biggest one. And there are several other cases that are still pending that we're watching closely and that are interesting. Last year, Meta also sued another company called Voyager Labs. And this was a somewhat similar case, except here Meta did allege that Voyager was collecting data from behind the password wall. And when Denas and I talk a little bit about the use cases later, you'll see that this is one of the key questions. What is in analyzing the legality of scraping activity? And the question is the data public or is the data protected in some way? And so here Meta alleged that Voyager was creating thousands and thousands of fake accounts so that it could collect data from behind the password wall. And interestingly, the only claim in the complaint was for breach of contract. Frequently, when you see social media companies sue a scraping company and there's an allegation that they create fake accounts, you'll often see not just breach of contract, but also a Computer Fraud and Abuse Act claim, which for those who follow the industry was the primary claim in the Oxylabs versus LinkedIn case, and several others that followed it. Sometimes you'll also see a copyright infringement claim for circumventing measures to protect copyrighted material, an anti-circumvention claim. But here, Meta just only sued for breach of contract. That case, even though it was filed a year ago, it hasn't really progressed very far. There's some fighting about whether Voyager is subject to the court's power, subject to the court's jurisdiction or not. And so there's been a lot of motion practice back and forth. So that case hasn't really gotten into the substance just yet, but it's a very interesting one that we'll be watching closely. And then sort of the last category of cases that I wanted to briefly touch on is we noticed that in the era since Twitter became X, since it's been under new management, they've been much more aggressive on the scraping front. It used to be that they weren't one of the common litigants, one of the common parties filing lawsuits against scraping companies. But just in the last several months and about, starting about a year ago, they really have started ramping up their activity and policing their platform more in this way. And so I'll touch on a handful of lawsuits that X has filed. First one is against Bright Data, the same company that Meta sued. And so X sued them. Now it's been about a year ago, and there's been some motion practice in that case too. And just from this past January, a few months ago, the case was very much in the news because there's a judge here in San Francisco who is known to speak his mind. He's not shy about sharing his thoughts with the parties. And the judge in that case at a hearing told X, "You don't own the internet," and that kind of made lots of legal headlines around local publications. And the reason he said that was because he thought it was not appropriate, basically, for X to be saying, yeah, this data can be public for some, but not for others. And maybe you're bound by our terms of service, even if you don't agree to them. Those are the issues that were being discussed. So right now there's a motion pending, another summary judgment motion on what is described as the browse wrap claim. And so the idea there is that browse wrap refers to a way of agreeing to terms of service where you don't actually have to click through. You just by scrolling through the website, browsing the website, if you see the terms of service and you continue to use the website, you can be deemed to have agreed to it. And so Bright Data is challenging the idea that a contract can be formed that way. And that motion has not yet been decided. Then there are two other sort of interesting scraping lawsuits filed by X. The first one against a nonprofit called the Center for Countering Digital Hate is also filed around the same time as the Bright Data lawsuit last year. And in that case, X sued for breach of contract, Computer Fraud and Abuse Act, intentional interference, and inducing breach of contract. These are sort of very common group of claims that you see in scraping lawsuits. Now, interestingly, that case got thrown out pretty quickly. Just a few days ago, the court completely ruled in favor of the nonprofit and against X, and found that what the nonprofit company was doing was protected by the First Amendment here in the United States, which protects free speech. So the judge found that X was suing them not because of their collection of data, but because of their analysis, which had to do with trying to police hate speech on the platform. And then the last one, which is interesting, and I wasn't able to find too many updates on this one because it's in a state court, but we're also tracking this one, is that X sued a number of anonymous users just based on IP addresses. And this was in a Dallas County court, a state court in Texas. And what's interesting about that case is that they weren't able to find the names of any individuals associated with the scraping. So they just sued anonymous IP addresses. And also interesting is the only claim in that case is for unjust enrichment, perhaps because they couldn't identify whether the users had ever agreed to their terms of service or what other activity they were engaged in. So these are the cases that we're kind of watching. There are also many, many cases in the AI world, obviously, that involve scraping and copyright claims. Those cases, most of them are not very far developed, so I haven't put them on the slides here. But it's obviously one that we're paying close attention to. Many of them seem like they'll be settled through license agreements, but that's not certain yet. That's kind of just what I've heard in the industry, is that the parties there are discussing licensing terms.
Great. Thank you. Thank you, Alex. Thank you for the overview. I really appreciate it. If you could briefly go back to the Meta versus Bright Data case, what do you like? Could you elaborate a little bit more on what is the intentional interference claim, and like how important is it in the web scraping cases? Like what are the legal implications of this claim?
Sure. Yeah. So we see this claim arise. It's one that many of our clients, we work with probably a couple dozen different companies that are engaged in scraping, and so we review a lot of cease and desist letters from Meta and other companies. And intentional interference is a claim that they often include both in their lawsuits like this one and just in their letters that they send out. And so the theory in general is Meta has terms of service agreements, so contracts with many, many users, and those contracts prohibit certain things, including scraping. And by scraping, you're interfering with those contracts. And it could be because the company is encouraging other users to violate the terms of service, or it could be just that they're kind of getting in the way of those contracts with their users. And the reason I said that there was a lot of speculation that the claim was just kind of be dismissed, or the parties would get rid of it so that they could appeal is because it's usually not the claim that is driving the litigation. It is a somewhat complicated claim to prove. If you're trying to prove that I interfered with your contract with a third party, you have to show that I'm, in general, it kind of varies depending on what jurisdiction's law applies. But in general, you have to prove I'm aware of the contract and that I did something that was wrongful, unlawful, that with the intention of interfering with your contractual relationship with a third party. So it's somewhat complicated, and you have to prove that I did something that's separately unlawful anyway. And so usually the focus is on, well, what's the conduct that's unlawful? And the intentional interference claim is just kind of like a Me Too claim. They just add it on as another way of proving liability and sort of beefing up their case. This is usually not the primary claim that companies are pursuing, but it's one that we pay attention to when we get cease and desist letters and analyze and talk about with our clients.
Great. Thank you, Alex. And one more question before we go to our hypothetical scenarios. So it feels like when it comes to web scraping and legal cases, like there's trends like fashion. Some come, some goes. There was this Computer Fraud and Abuse Act trend. Then there's this terms and conditions claim, breach of terms and conditions claims, and so on. So what is the next hot question that the U.S. courts have to answer after the Meta and Right Data case? Like, what is the next legal frontier?
Yeah, it's a great question, and I agree with you. There are sort of trends that happen in this industry, and Computer Fraud and Abuse Act is now out of favor. You still see it sometimes, including in some of the cases that I mentioned, but it's less the focus. So I think that a couple of questions that are unanswered by where things stand right now. I mean, first of all, I should say that the Meta versus Bright Data case is very, very important. And the judge in that case was the same judge from the HiQ versus LinkedIn case. So he sort of has a reputation and he knows a lot about this area, and he's a well-regarded judge, very, very smart, very intellectual judge. And so he knows quite a bit about this area. But with all that being said, it's just one judge in one lower court. And so it doesn't really have implications beyond just that one lawsuit, except that future courts might look to it as being instructive or interesting. It doesn't bind other courts to follow. Other courts are not bound to follow that ruling. They may find it interesting and persuasive. It is a very well-written opinion, but they don't have to follow it. But so sort of what's the next frontier? I think one question that's left unanswered by that case, and it's an area that has been undecided in US law for some time, is this browse wrap question, which I mentioned was at issue in the Voyager Labs case. Or sorry, not
in X and
in the X case. Yeah, that's right. In the X versus Bright Data case. And so the question there is, can we create a valid and enforceable contract if all I do is host a website and put my terms of service on it, and all you do is visit the website, see the terms of service, and then continue using the website? And there are a number of cases, really from all over the country, that say, yes, that can be a valid contract, that if you know what the terms of service are and you come back and continue violating them, that you're doing that intentionally, and you know sort of what the price of admission is to the website. I've told you the price of admission is no scraping, and yet you come back and continue scraping. And so you're doing that knowingly, and I should be able to sue you for violating the terms of service. There are a number of courts that rule that way. And there are a number of courts that rule the other way and say, no, to have a contract, I have to affirmatively agree. And just knowing what your preferences are for how I should use the website doesn't mean that I'm obligated to follow them. And so there are a number of cases on, going either way. And I think this Meta versus Bright Data case doesn't tell us exactly where this court would come out. There are a few references throughout the opinion that suggest probably this judge would say, no, that's not an enforceable contract. And I think if you look at the overall trend of scraping cases, which include this Meta versus Bright Data, HiQ versus LinkedIn, Sandvig case, the Van Buren case, several others, there's a general trend toward reducing the penalties for collecting data that is otherwise publicly available. If it's behind the password wall, that's kind of a separate question. But the general trend of these cases is if it's on the internet and it's available to everyone, then it should be usable by everyone. And large companies shouldn't be able to put up walls around the data and say only some people can see it and other people can't. So I think the trend is toward a more open internet, but it's an undecided question.
Great. Thank you a lot for this, Alex. And I think we can move on to our first hypothetical situation. So hopefully we'll be able to cover all three prepared situations, but even if time only allows us to unpack the first one, I'm confident it will set a solid foundation for the compliance mindset we want to cultivate among our audience. And I see that there's quite a lot of questions in the question section, and so we'll try to have some time to retain some time to answer those questions if we'll manage. So I'm gonna go to our next slide, and it's our case number one. So the background is there's Example Commerce. We'll call it EC. It's a European-based e-commerce company specializing in home goods, clothing, and electronics. EC's biggest competitor is Always Buy. We'll call it AB. It is based in the United States. EC's commerce department requires constant updates on AB's stock and price changes. EC wants to extract product information from AB's website to achieve that. As a result, EC will need to scrape and parse the full HTML of product web pages. There's some key considerations also for us. So the data points in question can be accessed without logging in. Another one, AB employs various anti-scraping measures like IP blocks, CAPTCHAs, and so on. Also, AB's website's terms and conditions prohibit using automated means to access its website and content. So we have this situation. And Alex, I know that a big thing that at least in Oxylabs, a big thing we always keep in mind to stay clear of the biggest legal hurdle out there is the Computer Fraud and Abuse Act. I think even its name portrays it as kind of the biggest boogeyman of them all. Could you share a bit about why is it so daunting, and what kind of question should be raised in EC's place, and what kind of circumstances are important here for the start?
Sure. So let me touch on the Computer Fraud and Abuse Act question first, and then we can talk about this hypothetical scenario. So the Computer Fraud and Abuse Act, it certainly is the most daunting weapon that website, data platforms, data providers on the internet have. And the reason is that it carries potential criminal penalties. And there's also a case, an important case, it's about 8 years old now, from the Ninth Circuit called Facebook versus Power Ventures, where the Computer Fraud and Abuse Act was one of the claims, and the company's individual executive, its CEO, was held personally liable, which is rare in the United States. Normally, if you're doing something through a company and the company is the one that's doing the activity, the individual executives are protected. That's one of the purposes of a company. So for those reasons, it is a very intimidating law for scraping, and it the history of that law is that it comes out of really from anti-hacking. And so it arose, in the late 1980s and early 1990s to prevent hacking, where you're actually kind of penetrating. At first, it was only government servers, penetrating a server, using hacking tools. So, you figure out somebody's password, or you get through their software defenses and you steal information. And then over time, the law got broadened to the internet context, and large social media companies in particular argued, look, every time you visit my website, what you're actually doing is you're accessing a server that I own or rent, and the server is the one that's putting the website up on the internet. And so if I tell you you can't access my website anymore, and you still come back, then you're violating, you're accessing my server without my permission, and so the law applies. And for a long time, that tool was effective. And then there are a number of court cases where it became clear that it doesn't apply quite so broadly. But it's still something that we consider, and in particular, something when it comes to use case number one here, it's something that we think a lot about when we're talking with clients. One of the first questions we ask is the data that you're collecting publicly available? And one of the questions here from Albert in the chat room asks this question: is it legal to scrape publicly available information? And so generally, what the trend for the Computer Fraud and Abuse Act theory has been is that if the data is publicly available and accessible by anybody with an internet connection, you don't have to have an account, you don't have to have a password, then in general, the Computer Fraud and Abuse Act probably does not apply. Other claims could still apply. And so when I look at this use case, the things that jump out to me are, number one, the data is publicly available. You don't have to have an account to access the data.
So Alex,
yeah, go ahead.
If I can stop you here. So to stay a bit on the public, on the accessibility aspect of the data. So
Sure.
Only the sole determinator of data being public or non-public is whether it is accessible without an account or without paying for it, like without going around paywall, or there are other, let's say, is solving CAPTCHA. Does it make the data not public anymore?
It's a good question. So the cases that have analyzed it kind of depends what legal theory you're talking about. So the cases that have analyzed, the cases that have analyzed the Computer Fraud and Abuse Act claim, in general, they have analyzed a situation where there's a password and login, and that's the line that they've drawn between public and non-public. There are other cases, though, analyzing potential copyright claims that talk about CAPTCHA as being technological defense that can protect copyrighted materials. And so it's not totally clear under the Computer Fraud and Abuse Act case law. At least I have not seen a case where a party tested that question of CAPTCHA. It may be out there, I'm just not aware of it. Whether CAPTCHA by itself is sufficient to create basically a Computer Fraud and Abuse Act claim if you get past the CAPTCHA. The cases generally are talking about creating an account, or in the case of Van Buren, it was a private database that was maintained by a police department, and it was a police officer who was accessing it. So the question was whether he was accessing it beyond his permission to access it. So in general, when we're thinking about Computer Fraud and Abuse Act, what I tend to focus on is can anybody with an internet connection access it, or do you have to have a password? Do you have to pay? Is it protected in that way? That's generally what I pay attention to.
Okay, so the rule of thumb, if I can see it as a consumer, it's in the light of Computer Fraud and Abuse Act, it's probably publicly available, and we kind of check that mark.
Yeah, I think so. And in general, and maybe this would have been a good place to start, but in general, the way that I think about scraping activity is it's kind of a spectrum of risk, right? And there are things that are much less risky, Although it's hard to say that any business has no risk at all, right? If you sell a product, and if you sell pacifiers for babies, it could hurt the baby, right? Like every business has some risk. Scraping is no different.
Yeah.
And so even collecting data that is purely publicly available, not behind a password wall, has some risk. It could violate terms of service. A court could rule that just posting the terms of service creates a binding contract. So there is some risk, even if the data is completely publicly available. But it's one of the first things that we look at, because it is much less risky to collect public data than to engage in creating fake accounts or somehow get past a password wall.
I think this is a great insight, because usually in scraping projects you exactly do that. You evaluate the risk level. It's understanding that it's hard to be completely risk free, because there's always arguments even in the courts for and against. But so in EC scenario, probably basically, if we have a condition that you don't need to log in, and even though AB employs various anti-scraping measures, it's we still probably can say that it is a public data. So, and after we get past this hurdle while evaluating this scenario, so what's the next legal topic EC should think about?
Yeah, so you and I talked a bit about this, but so one big question, and usually a place that we start, is the data publicly available? How is it being collected? And then another question is, what kind of data is being collected? And this use case really talks to that. And so the reason that matters is it matters for a number of reasons, but a big reason it matters is because of copyright risk. And you see this with the AI companies. The AI companies are out there scraping sort of information that is at the heart of why we have copyright protection. They're scraping entire movies. They're scraping entire books, novels, comedians' routines, right? They're creating transcripts of videos. So highly creative, lots of expression, sort of the core of copyright. And they're scraping that stuff to create their language models and their other tools that they use. So that's very, very different than scraping price information from an e-commerce website, as in this scenario. Price information, how much does a good cost, or where was it manufactured, or what are its attributes? That almost certainly is not copyrightable. Data like that in the United States is not subject to copyright protection, with very limited exceptions. If you have sort of like a database structure with all of that data, then maybe it could be copyrighted. But just the price of an item that's being sold online, it can't really be copyrighted. And so when the second thing that jumps out to me from this use case is the types of things they're collecting in general are not copyrightable, but perhaps with some exceptions. And so, if EC were my client, I would want to ask them, okay, so the main thing that you're doing is you're checking up on the company's stock and its price changes. So that kind of information probably is not copyrightable. But then lower down it says EC will need to scrape and parse the full HTML of product web pages. So that suggests to me that possibly EC is copying everything that I see when I'm looking at AB's product on the website, which might include a photo, it might include a product description, and it might include reviews from consumers that have used the product. So all of those things, photos, product descriptions, those could be copyrightable. Now, does an e-commerce website really care very much about their product description? Probably not. Do they care that much about the photo that's used? Probably not very much. And for most e-commerce websites, if you think about Amazon, for example, it could be that the e-commerce website itself created the photo and the product description, or it could be a third party that's just using it for using the platform to sell. And so who owns the copyright is going to be another question that I would want to think about with this
Yeah.
client.
So
What kind of data is being collected is a second important
yeah.
question.
So so basically on the same page we can have factual data, but we can also have copyrightable data. We can probably, if there's comments on the reviews, we can even have personal data on the same page.
Yep.
So I guess it matters for the scrapers, for the companies that scrape, to really evaluate what type of data they actually need and to identify whether they are able to scrape only that part of data. But I have a question here. So let's say they actually still need to scrape the full HTML of the web page, but for to parse out only the necessary fields. Like, does it matter that if the EC will scrape the full page, but will only use, let's say, the factual information, the price and the stock numbers, but scrape the full page, but leave it out?
Does it? I think it matters. Yes, it matters for sure. It's different than, for example, if that use case is different and less risky than, to take a similar example, if I were scraping the full HTML of every product page so that I could just put the same information up online and offer the exact same product through my platform. If I were doing that so that I could just mirror my competitor's website, that would be more risky. And so it matters that what EC is doing here is, although they're copying everything, they're only using some of it. That certainly matters. It's less risky. But purely from sort of a copyright infringement perspective, they've created a copy of everything. And the fact that they're not using it might affect the damages that would be available. But they have, assuming that the photos and the product descriptions are copyrighted or copyrightable, they have created a copy, and so they've infringed their competitor's copyright.
Okay, thank you. So I guess it matters, but also the scrapers have to think about not only how they get the data, what type of data they get, but what they do with that data as well. Okay,
yeah,
so
I think that's right. And sorry, just to jump in, one of the things that we're frequently talking about with our scraping clients is risk mitigation. How can you, if you're in this very risky end of the spectrum, how can you move back toward this way and still run your business? And so for this client, one of the things I would ask them is it possible, does it work for you if all you need to do is just pull out price so that you're not collecting the copyrightable stuff as well? And if the answer was no, we really need to copy the whole page, I'd say, okay, well, think very hard about what you do with all of the stuff you've copied after you've extracted the information that you need. How long do you hang on to it? Is there any argument that you're sort of creating an archived version of your competitor's website that you could use in the future for some other purpose? If you don't need the data, then get rid of it. There's no business purpose, just get rid of it. And so we often talk about sort of data storage practices as well, because it's very common for our clients to collect a lot more data than they actually analyze and use.
Yeah, great input. Thank you, Alex. There's also consideration about no worries about the terms and conditions of AB. Obviously, it prohibits automated access to its website and contents, and there's this whole probably it's relevant what you talked about previously about the browse wrap and click wrap questions. So what should EC do if AB's terms and conditions preclude from scraping?
Yeah, I think the law is really sort of in flux in the United States on that question, and so the place I would end up with counseling this client, I think, is you should be aware that there's some risk of breach of contract, but you can't really run your business without accepting that risk. And there's no real way to reduce that risk. You can't ask them to change their terms of service, or you can't forget that they have terms of service now that you know. And so there's not really a good way to reduce that risk, except the one thing that I would also tell these clients is, if you get a cease and desist letter from your competitor, we should talk again right away, because that does increase the risk. And there's case law suggesting that if you just have kind of a general awareness of the terms and you're scraping in violation of the terms, that might not violate the terms of service. But once you receive a cease and desist and the company has given you very formal, clear notice of what the terms of service are, now you really, really know for sure. And so courts tend to think of activity after you've received a cease and desist a little bit differently. Not every court, but a lot of courts think about it as more risky and more clearly violating the terms of service.
Great. Thank you, Alex. And I know you'll love my next question. 5 out of 5 legal gavels, 5 being very, less risky, 1 being very risky. How many legal gavels does EC scraping project receive?
So five is the most risky?
Is the least risky.
Oh, 5 is the least risky. Okay. I think that probably this is within the scraping world. What they're doing is definitely more toward the safer end of the spectrum. So I'd probably put it at like a 4 within the scraping world, accepting that, if you're scraping, you're always going to be taking on some legal risk. This is relatively safe. The one thing that we didn't talk about, and it kind of comes up in one of the questions from Fabian, is does the size of the company matter? And here, because the scenario mentioned that these two companies are primary competitors, that increases the risk a little bit, because both companies are certainly aware of what the other company is doing. They're both watching each other. And I work with many, many smaller companies that part of their strategy is, I'm just going to fly under the radar. These big, huge social media platforms, there are too many companies for them to pay attention to. And as long as I stay small, it's less risky. And there's some truth to that. The bigger you are and the bigger presence you have on the internet, and especially if you advertise on the platform that you're scraping, the more likely it is that you're going to attract attention.
So Alex, the number would be?
I think it's probably about a 4.
Nice.
Pretty safe. There's some ways that it can probably reduce its risk.
Great. Thank you for the evaluation. I promise I will not ask the same question after other scenarios.
Okay.
So we don't have much time left, but maybe let's try to run through the next one, really quickly, trying to identify like what's different in this one. So the next one is case number 2. So there's a Best Labels. BL is a market-leading record company. BL licenses its content to music streaming services, including Musify and Popify. BL's licensing team decided to audit their licensees to ensure compliance with the licensing agreements. BL plans to do it via automated means, obviously, and BL will use proxies, log into streaming services, which the streaming service cannot be accessed otherwise, and download BL's licensed content, and then analyze whether they're using in accordance with the agreement, with geo restrictions and so on. Some key considerations: BL's and Musify's licensing agreement allows BL to audit Musify's use of BL content, but the audit methods aren't specified there. The BL and Popify license agreement doesn't cover auditing question. And both BL and both Popify and Musify implement anti-scraping measures. And both streaming service providers' terms and conditions expressly prohibit scraping. So, Alex, what would you highlight that is important in this situation? Like from our last scenario, understand that it is not publicly accessible data. And does it mean that BL automatically agreed with terms of service of streaming platforms by logging in?
Yeah. So the short answer to that is yes. If you create an account, whether it's sort of a direct company account or you're using a third party to create accounts for you, by creating the account and getting a login and a password, you're agreeing to the terms of service. So I do think that analysis applies to this use case. The main thing that jumps out to me in this use case is sort of what we were just talking about, which is the law is going to apply sort of regardless of how big or small a company is. But in reality, it matters. It matters how big your company is, and it matters your economic relationship with the platform that you're scraping. And so here, the biggest fact that jumps out to me from this use case is not really a legal one. And the issue is Best Labels here is the owner of the content that's going onto the platform, and there's an economic relationship. The parties are, Best Labels is providing music and the platforms are sending it money. And so one of the first questions that I would want to talk with Best Labels about is, how important is your music to these platforms? How big is this deal? Are you a tiny, tiny publishing house that these platforms don't really care about? If they lost your music, they wouldn't even notice? Or are you one of the largest, record companies in the world, where you've got, Beyonce's new album, and if you don't license it, no platform is going to be able to have that music on their platform. And the reason, it's not really a legal reason. That behavior is the same and the law should apply the same. But in reality, is a platform going to go sue one of the largest, most important record companies in the world that they need to have an economic relationship with? Probably not. They might not like what Best Labels is doing in this use case scenario, and they might grumble about it. But the legal risk is lower, not for legal reasons, but just for commercial reasons. So that's one of the things that I would want to explore. Sort of what's the economic relationship. And then the other things that jump out to me here are the fact that one of the licenses or one of the agreements allows auditing and doesn't specify what that means. So does that mean that Best Labels can audit however it wants, including by scraping? Probably not, but it gives it some kind of argument that, all we were doing was enforcing our contractual rights. And so the platform where it's scraping, I guess it's Musify, where auditing is allowed, but methods aren't specified. I'd say that's slightly less risky than the other one, where there's no auditing allowed, because it gives Best Labels some argument that, you knew that we might do something like this. We just didn't discuss exactly how we would do it. So that's another, I think, key fact. And then, we already talked about the need to create accounts.
And I guess it's please, Alex.
Sorry. The last thought I had is I would also want to talk with this client about something that we talked about earlier. How much data are they collecting? Are they going into these platforms and doing a really targeted search where all they're collecting is music that they have licensed or music that they own? Or are they collecting, a whole bunch of data so that they can do some kind of competitive analysis and figure out how frequently are their songs being listened to or liked or shared versus other competing music? And so if they're doing it just purely for audit reasons, that's a safer behavior especially for Musify, where they have an auditing right, than if they're doing it for some broader competitive purpose. And something that I talk with clients a lot about is you got to be careful, because you might start this project thinking, oh, all we're doing is auditing. But then you get this massive amount of very interesting data. And all of a sudden, the people who collected the data say, whoa, there's so much that we could do with this. And they start using it in ways that you didn't originally envision. So the legal function of this company would need to just have very clear parameters for what kind of data is collected, how is it used, how long is it stored, all of that kind of stuff.
Great. So I think this could be a really important takeaway for our listeners. Just what you said, to really think about like the least amount of data, to how to achieve your result with the least amount of data, and to actually think, what are you doing with it, because it matters. I guess if court happens, it matters. How whether you were acting in good faith, how much data you were taking, how careful you were with the servers of the target website or app, and so on. So I see that we have run out of time. We had one case left. This is a really new format for us. So if we'll receive, feedback that this was interesting to our listeners, maybe we'll do this scraping evaluation once again. So I see that we have some questions unanswered, but we have this Discord channel of Oxylabs. You can we release lots of news there, and you can chat with us. We can try to answer your questions in there. So, Alex, many thanks for joining on this new venture, new format. It was very interesting for me, and thank you everyone for joining and listening to us.
Well, thank you, Denis, and big thanks to Oxylabs for kind of leading the conversation on this stuff. It's really interesting, it's fast changing, and I'm happy to be with you today. So thank you.
Great, thank you.